Alrighty. Hello, everyone. I'm Ariana, and I'm back to host our September webinar this month with a new presenter this time, attorney Robert Merding. He has a personal passion for firearms and authority on the laws regulating them, making Robert the go-to attorney for firearm-related legal issues. He's located in South Carolina, and Robert was born and raised in the state, only leaving to pursue his law degree in Virginia at Washington and Lee. He has, of course, returned back to South Carolina, where he opened his own practice in business law and estate planning with an emphasis on firearms. Whether it's buying or selling an NFA firearm, passing down a collector or a collection of guns, defending firearm-related charges, or operating a firearms-related business and complying with regulations, Robert has helped tons of clients achieving their goals. He brings substantial legal knowledge in both firearms and firearms law to help his clients. He's highly organized, and Robert knows that planning is a necessity in law and that clients benefit using an experienced planner in business and in personal matters. Whenever your work requires documentation, Robert's very happy to help you plan and then also execute that plan, of course. So we are very excited to have him here to join us tonight to present our webinar over this Bruen decision. So, from what I've learned from my research is that back in July, the Supreme Court struck down on New York's strict rules for concealed carry permit applicants to demonstrate a proper cause or special need for self-defense. But of course, we have our expert here, Robert, to discuss this case history and possibly it could be leading to reshaping gun laws. But again, thank you all for everyone joining this month's webinar. We'll also have a Q&A portion at the end, so make sure to leave any questions in that comment section, whether you're watching from Facebook or YouTube. And also, I'm going to mention that we also have a giveaway occurring this month until September 30th. I'm going to pop up an image of everything that you could possibly win. But just click the link in the description from YouTube or Facebook, and as you can see, there's a Savior pistol bag in here, Otis cleaning kit, Walker's Ear Pro, and even more. Just had to give it a mention so you can have the opportunity to win. Now, here comes the part that you're all here for. Robert, it's your turn to start talking to explain this Bruen case to me and your viewers.
Ariana, thank you for the introduction. So we're going to talk about Bruen today. I'll first say hello to my fellow members from South Carolina. I see at least one over there. So Bruen starts actually 111 years ago. In 1911, we had a great pistol invented, but the governor of New York, Sullivan, passed a law that prohibited the carry of firearms in New York, the state proper, unless one got a permit, and that permit had to be gotten with proper cause. So that is what tees us up for a court fight 111 years later. At the time that law was passed, it was really about being able to block certain unsavory people from having firearms in public and then allowing those that they wanted to. That was a much more common practice, if you will. As time developed, the proper cause, not defined in the statute, did get defined by the courts. And the courts came in and said, basically, proper cause is, I'm going to read you the quote here, if an applicant can demonstrate a special need for self-protection distinguishable from that of the general community. So special protection distinguishable from that of the general community. By the very definition, somebody has to not be the common man to be able to show proper cause. So it's categorically, this law is going to deny the commoner, the average person, from a self-defense right in public. And that's exactly what has happened. The law was administered such that those with money, those with connections were able to get their permits, and the average person could not. So where does that lead us in 2020, 2022? New Yorkers can't get permits. New York doesn't honor permits from any other state. And so after Heller deciding that the Second Amendment is an individual right and McDonald applying that right to the states through the 14th Amendment, the New York Rifle, State, and Pistol Club got the idea to bring suit and challenge the may issue. That's the court's terminology, also common terminology all may realize with CWP law, the may issue, meaning the state may issue it, but they may choose not to. They brought that challenge in a district court in New York. Now, they knew that that was going to be a hard challenge. Pretty much Second Circuit had already come out and said that the New York law was constitutional. They'd upheld it. And because the Second Circuit had upheld it, the district court was bound to also uphold it. Stare decisis, following precedent, they couldn't do anything. So when our petitioners made this file, they knew they were going to lose immediately at the district court. That shows you an idea of what seriousness they had. They also realized that when they appealed it to the circuit court, well, they knew what that circuit was already thinking. It would have to reverse itself. That was an unlikely chance, but it was their first chance of success. As would be expected, knowing the Second Circuit, knowing how they've held on firearms law before, the Second Circuit denied the petition. They appealed again, and that put them in front of the Supreme Court. And this was their first real fight, and quite frankly, the last fight that mattered, because there is no appeal after this. And that's where they went and where they had their success. So why was this a case that New York was willing to fight on? It would seem apparent to many of us in the firearms community that the right to own and bear arms shall not be infringed. Bear as carry shall not be infringed would mean you can't keep them from being carried. That seems logical. Well, it has to do with how the courts, the appeals courts, had come across with a test for applying the Second Amendment. So, Ariana, I'm going to get you to do a slide for me. Number 2, it's the two-part test. So here we are, the nice, simple, easy test that all the circuit courts had come together with. This actually had coalesced around it to use the Supreme Court's rule, the Supreme Court's terminology. So I want you all to read this and study it. It's going to tell you that first we have to know whether or not the challenge laws imposes a burden on conduct that's within the Second Amendment. Now, some conduct might not be within the Second Amendment. And some of the leanings on that seems to be the carrying of dangerous weapons to cause terror. Then if the conduct is within the Second Amendment, we next have to figure out how close it is to the core. And as the Supreme Court critically said of the lower courts, that they only seem to find the core of the Second Amendment in carrying firearms in your home. And that the Supreme Court would go on to reject that as being, quote, the core. But we have to figure out how close it falls to the core. If it falls very close, we apply a strict scrutiny, and we do then a means balancing test, or we apply intermediate scrutiny, then we do a means balancing test. Well, the Supreme Court, after looking at all the circuit courts, they've all agreed to what this is going to be and how to apply this test. And then you're seeing it in the Second Circuit, the Ninth Circuit, the Fourth Circuit. It's ubiquitous. The Supreme Court said, you got it wrong. So all of you who are studying that to memorize it, I'm sorry, it's now in the trash heap of history. Ariana, give us the next slide on this one. Supreme Court came up with something quite a bit shorter and quite a bit easier. Basically, the Supreme Court held that the two-part test was one part too many. So what does that mean? The Supreme Court said that the Second Amendment is not subject to a balancing test. Rather, the Second Amendment is actually a balance that the people made. And they resolved those questions of balancing in favor of lawful citizens being able to have guns for self-defense. What this means is we only deal with the first part of that question, or the first part of that test, the first question. And that is, does the plain text cover the conduct? And if it does, then can the government find a history of regulation that was consistent with the adoption of the amendment? So how does this rubber meet the road? Well, what we're really looking at is when the amendment was adopted, it codified an existing right. Did that existing right mesh with certain restrictions? So we look back as far as, statutes in Northampton, which is what those who would regulate firearms really want to grab a hold of. And we look to laws of the antebellum period because there's an adoption of the 14th Amendment. And then we look to the laws around the colonies. And there's some laws in the north eastern colonies about the carry of guns. And mostly there's some laws about the carry of guns in sensitive places. Ariana, I'll get you to pull up the sensitive places. I think that's the third slide. So sensitive places historically, legislative assemblies, polling places, courthouses. Those are the only three examples that the Supreme Court comes up with. And those are the restrictions that we actually would have seen in 1791 when the Second Amendment was adopted. Interestingly enough, the court answered very few questions. It was pointed out by some of the concurring justices things that weren't decided. Justice Barrett made clear that we did not answer whether we look at 1791, when the Second Amendment was adopted, as the appropriate measurement of what was allowed and what wasn't allowed, or whether we look at 1867, 1868 Reconstruction, when the 14th Amendment was adopted, is what's allowed and what's not allowed. And that's going to be a very interesting question, because during the antebellum period, we saw a lot more states starting to regulate concealed carry. And how you carry a gun was regulated very strictly in some places. Interestingly enough, if we look to the Second Amendment corollaries, that is the language like the Second Amendment in all the state amendments, many of these state amendments actually explicitly allowed the state legislatures to regulate how guns were carried, or some cases to prohibit the carry of concealed firearms. So that's an interesting tidbit in how those amendments were understood in, say, the 1830s, 40s through maybe the 1870s and 1880s, that I think gives some light to how the Second Amendment itself is understood. And part of that has to do with some of the laws, case coming out of Kentucky that found that the Second Amendment corollary in Kentucky was an absolute and did not allow for any type of restrictions. It seems to be a bit of an outlier, and that's an important thing to note, because the Supreme Court here threw out some other outliers in New Jersey and some other states or colonies that stood for a short period of time prohibiting the carry of guns. So there are some laws or examples all over the map, if you will, with history, but they coalesce kind of around the fact that you had some sensitive places you couldn't carry firearms, and generally speaking, otherwise, you didn't have total prohibition on carrying guns. It was that total prohibition for New York that got New York into trouble. And that was a total prohibition based off of the way we read the proper cause of Bruen. So Supreme Court looks at this, and we get a variety of opinions. Like any good case, we're going to have our naysayers, our dissenters in it. What is surprising more than the dissenters is that we have three concurring opinions. So a lot of the justices felt a need to come across and say, hey, here's what we're doing, here's what we're not doing, and give their 2 cents. Alito's the first on that. And Justice Alito came in and said, this is a very limited decision. We're looking at purely whether or not the common man can carry a firearm for his self-defense. And we're not looking at anything else. And then he gets very critical of the dissent, which brings in a bunch of, a parade of horribles, if you will, about all the crimes being perpetrated with firearms. And Alito says that's not relevant here. We're not talking about who can own guns, where guns can be carried, or what type of guns can be owned, what background checks are done. All we're talking about is, can the common man carry? And that is a clear yes. Justice Kavanaugh brings in his second concurring opinion. He wants to make clear basically 2 points. First is that nothing within this opinion is going to question licensing regimes in shell issue states. He said there's nothing there that we're doing that's going to invalidate those. So the court is kind of tipping a hat there that they may very well hold up any type of licensing schemes, which goes against some of the precedent you will hear quoted about a right licensed into becomes a privilege. The second thing that Kavanaugh hammers at the Second Amendment is not a straitjacket. It doesn't allow anything to go, and it doesn't prohibit all regulations. It allows some regulations and it prohibits others. He then quotes back to the language of Heller, the infamous language, if you will, that says nothing in here prohibits the longstanding or questions of longstanding prohibitions on felons owning guns, mentally ill people owning guns, regulation of machine guns. What's interesting, juxtaposing Heller with Bruen, is that Heller ostensibly doesn't question some of those regulations because they're longstanding. The regulation of felons owning guns, regulation of mentally ill owning guns, both passed in 1968, well more than 50 years after Bruen's law, Sullivan Law of 1911. The machine gun, I saw NFA some questions being asked on that. Machine guns were prohibited for most ownership in 1934, another 20 years after Bruen. So it'll be interesting how that part plays out with what really is long-standing if the court doesn't mind striking down a law that's more than a century old. Justice Barrett, in her concurring opinion, raised the question that we haven't decided which period matters when we're looking at the ratification of the amendments. And again, that's as we discussed 1791 versus 1867, which one's relevant. And honestly, that could be both. If we're talking about a federal regulation, then the 14th Amendment does not really change the Second Amendment. It didn't apply it to the federal government. It was already applied in 1791. But we could argue that if we're talking about a state regulation, that the 1867 adoption of the 14th Amendment codified the existing right, and potentially that might be different when it comes to what states can and can't do. They might have a little more leeway. That's something the court will have to look at in future cases. And Justice Barrett also, on that same theme, said that this didn't decide how much emphasis to put on post-ratification practice, which leads us to a good point. The court here put all the emphasis on whether or not Bruen was legal. I say Bruen, the Sullivan Law figured out in Bruen, whether it was legal based upon the practices that were allowed in 1791 and 1867. They looked at those. And of course, when they looked at those, they said, hey, we can look at things that are earlier. The statute of Northampton goes back 600-700 years and is looking at what England allowed and didn't allow. Or they could look at stuff that was happening in the Reconstruction period and see what was being done there a few years after the ratification, post-ratification practice, if you will. New York wanted to argue that, hey, our post-ratification practice includes 1911 in their Sullivan's Law. That was obviously not enough to get them over the hump, which, is a good thing, that you can't have a post-ratification going 30, 40 years later. So I think we started down, Ariana, if you would go back to the slide number 2. So I started down with this with how did New York think they were going to win? Well, they looked at this test, and this test that was being administered by the Second Circuit and the other circuits would say that, hey, this conduct falls within the scope of the Second Amendment, but it's not the core, because the core was prior to Bruen, the home, because we're outside the home. Therefore, we get into intermediate scrutiny, and then we do a balance with intermediate scrutiny of, is there an important government interest, in this case, ostensibly reducing crime, and does this do something to further that interest, theoretically removing firearms? And the courts would uphold it. So they looked at the two-part test and they said, we've got a great chance of winning. Matter of fact, it seemed like a slam dunk to them. But the court did not necessarily think so. At least the Supreme Court did, and the Second Circuit went quite fine with it. So New York defended, and based on this test, I think the petitioners knew that they were going to have to go to the Supreme Court and challenge this test. All right, so I see a comment over here about historically concealed carry was always illegal. Not necessarily true. I mentioned the Kentucky case, and that was on a law about concealed carry. It was challenged in the 1830s, and the appeals court in Kentucky, didn't make it all the way to the Supreme Court, held that the Second Amendment corollary for Kentucky was absolute. They could regulate neither concealed nor open carry. And it was actually constitutionally protected, and the people of Kentucky responded in a formal, proper manner. I won't say it was the right conclusion or the wrong conclusion. It was just done correctly. They amended their constitution to allow their legislature to regulate concealed carry. So concealed carry has not always been regulated and still not regulated in some states today. Matter of fact, some states, depending on the type of gun, have never had certain concealed carry laws. Vermont is one of those. The pick on my own South Carolina, you can concealed carry a rifle. Good luck with the mechanics of that. So what did the dissent say in Bruen? Well, the dissent started strongly with all the societal problems you may see where a gun is used to cause harm. That could be anything from accidents to suicides to violent crimes. Of course, a lot of heavy emphasis was given to mass murders or maybe mass shootings. And in doing that, one of the things that one of our concurring justices, I don't remember which one off the top of my head, found to be ironic, I think it was Alito, was that one of the top 3 or 4 mass murders they named occurred in New York, where this law would supposedly have stopped it if successful. Common sense tells you that somebody who's not willing to follow the law to murder is not going to follow laws about paperwork and possession of inanimate objects. I think that the concurring judge was poking to that point. But the dissent starts with that parade of horribles of all the things that guns can be used for that are negative. And then it goes into how reasonable it would be, knowing these things, for the state to want to regulate those use of firearms to try to reduce this parade of horribles. And then it talks about balancing and allowing the legislature to balance, and how it's inappropriate for the judges to balance and do balancing tests, where it really is truly kind of a policy call. And I will give the dissent points that it is truly a policy call, and the justices aren't the ones making policy. Much of our very controversial cases we have seen in the past are the justices making policy decisions versus actually enforcing the written statutes and the written Constitution. In this case, though, the written statute, the written Constitution is rather clear. That is why I think the court hit it right when they said that the Second Amendment is the balancing, and it was the balancing test by the people. They made that judgment call. So the dissent goes on. 2 of the things that I found of interest that they raised is that, first, this case was decided without any hearing, without any discovery period, and that basically it was decided purely upon the complaint and the arguments. It was decided as a matter of law, if you will. That is interesting because we typically allow the litigants to do discovery, to see what the other person's views are, to find out what the evidence is. And only after all that is shared and we've had a chance to explore it, do we find that a case is ripe for trial. And then we do a hearing, we do a trial, arguments are made, case is presented, decision is made, and then you get to appeal. So actually here, all that got skipped. And it got skipped because of the stuff we talked about earlier, namely the Second Circuit already had their precedent in place. This was dismissed at a preliminary, if you will, proper terminology would be it was dismissed for failure to state a claim that had any recovery on it. But because that dismissal was right off the bat, then it got appealed. The Supreme Court, rather than saying, hey, we think you've applied the law wrong, go now do an evidentiary hearing, go now do discovery, we're going to make the decision based off the law. And the Supreme Court has that authority, they have that power that they exercise. And where something is egregious and it's clear that it's not constitutional, they can do it. And that's exactly what they did here. They said, hey, it's very clear that the Sullivan Law as being used is unconstitutional. The courts have defined proper cause in such a way that it denies this to the common man. The other thing that I thought the dissent made an interesting point is that they lament that the historical test that is being used now by Bruen, or on a slide number 3, if you will, again, removes from the legislature the ability to do a balancing test to make judgment calls, and henceforth removes that from the judges and the justices from being able to do that balancing test and make judgment calls. But then the dissent goes through and analyzes the same history that the court analyzed in the main opinion. And it makes the point that, well, if you don't minimize as outliers these examples, and you minimize as outliers these other examples, and you put more weight here rather than there, you could come to a completely different conclusion looking at the exact same history. Almost as if they're providing a roadmap to those that know where they want to go and telling them how they can get there, even though they're looking at the same history as the court looked at and determined that the Sullivan Law was unconstitutional. And that would be probably my biggest critique of the dissent, is that they start with the ends. They start with all this parade of horribles where guns are used by persons to cause harm, and say, we have to do something about this. These ends have to be adjusted. Therefore, the means justify the ends, or the ends justify the means. Sorry, got that backwards. And that ends justifies the means is not something I'm at home with, put it that way. So where does this take us now? We've got the Bruen decision out there. We got this new Bruen test here. One of the first things to take of importance is that's a new test. As I started off with, all the circuit courts coalesced around that two-part test, every one of them. So all 11 circuits were wrong. That means that every case decided since McDonald that used that two-part test, that's a decade's worth of legal precedent, were decided using the wrong yardstick. So all these cases are now up for relitigation, for review. We're on a fourth slide. So what, I'm sorry, Ariana, please go to the fifth one. So what that's going to take us to is some cases that we're going to immediately see pushback on. When Bruen came out, it wasn't the only Second Amendment case the court decided. The court decided 4 this term. The other 3 are right there on the screen for you. Each of those were very simple decisions. The circuit court was vacated. The case was remanded back for further decision in light of Bruen. So this is the Supreme Court telling their circuit courts, you got it wrong, try again. Study this being Bruen. So what are they? Well, we've got Duncan versus Bonta. Duncan is a challenge to California's magazine ban. California in the last few years has enacted a lot of anti-firearms law. They've enacted a ban on magazines that are more than 7 or 10 rounds. That ban was litigated against. Actually, it was found constitutional, I think, by the district court. It went up to the Ninth Circuit, where it was found unconstitutional. Then the Ninth Circuit said, we're going to have an en banc hearing, meaning we're going to take all of our justices in. We didn't like the 3 that heard it the first time. We're going to bring us all in and listen to it again. They found the ban was constitutional. And of course, they used the 2-part test. Well, now the Supreme Court has said to them, hey, your test was wrong. You don't get to do an interest balancing. You've got to decide purely, is this conduct that is under the plain language of the amendment? And if it is there any ban in history around the period of 1791 and 1867 that you can point to that makes sense to allow this? I think the Supreme Court's given a little bit of a signal there that those bans may be unconstitutional. How strong that is, we'll see. But they're giving that signal to the Ninth Circuit. We're going to see what the Ninth Circuit does with it. The next case is Bianche versus Frosch. Bianche is a challenge to Maryland's assault weapons ban. So a few years back, Maryland decided that they were going to cure all of societal ills by banning firearms that they called assault weapons. I still honestly don't think there's a single definition of that makes any sense. but they banned some semi-automatic firearms. That is another interesting case because of the dedication that the plaintiffs have had to bring it. And what I mean by that is we looked at Bruen. Bruen knew they were going to lose in the district court, and then they had a uphill battle to get any type of win in the circuit court. I'm sorry, the circuit court. In Bianche, the Maryland assault weapons ban had already been challenged. It had been found unconstitutional, I should say, by an en banc hearing of the Fourth Circuit. Much like the case in Duncan, the Fourth Circuit panel of 3 judges has found that the law was unconstitutional. The circuit said, no, we got to do everybody now, bring all of our judges in to make this decision. And they found it was constitutional. They upheld the ban. So that means when Bianchi filed this case, they knew that the district court was going to have to dismiss them. They had to follow the precedent of the Fourth Circuit. They knew when they got to the Fourth Circuit in the panel of 3, they had to dismiss them because they have to follow the precedent of the Fourth Circuit en banc. They would then either be able to appeal to the Fourth Circuit en banc, not able to get any different judges back in front of the same people, see what you get, or they'd have to appeal to the Supreme Court. So basically, they knew they were going to take it on the chin twice before they even had a chance. Whereas Bruen knew they'd had to take it on the chance once, then they'd have at least some chance. Bianchi and them, to their credit, did exactly what they set out to do. They took it all the way to the Supreme Court. What is most interesting to me is looking at these cases is that the Supreme Court said, hey, vacate it in light of Bruen, send it back, try again. Is that the case in the Fourth Circuit en banc hearing that upheld the assault weapons ban started out the decision with finding that the possession of assault weapons was not conduct protected by the Second Amendment. That's the preliminary question. They didn't get into interest balancing because they said, hey, these weapons aren't protected. If the Supreme Court agreed with that, that's really and truly their entire test that they have in Bruen is this within the plain text? So the Supreme Court signaling, in my quick estimation on this, that the plain text does include, quote, assault weapons. And if the plain text does include assault weapons, then the prior decision in the Fourth Circuit is wrong. If it doesn't include assault weapons and the prior decision in the Fourth Circuit was right, I'm not sure why the Fourth Circuit would need to relook at it. So I think there's a strong insinuation here by the Supreme Court that the Maryland's assault weapons ban is unconstitutional. We'll see if the Fourth Circuit follows. And then we get to Young versus Hawaii. And actually, these are not listed in a particular order, but they wound up being listed in a particular order. And that is from, I would say, least likely to be overturned to most likely. And it's very likely they could all be overturned. So Young versus Hawaii is a challenge of Hawaii's May issue law. It's a law that is very similar to what New York had. Matter of fact, the Ninth Circuit has already actually remanded this back down to the district in Hawaii and said, hey, you've got to reconsider this. And in doing that, they told it back down to the district court, said you need to, in light of Bruen, make a decision. When doing that, one of the judges of the Ninth Circuit said, we need to give guidance. Quote, from the Ninth Circuit dissent, Bruen held unconstitutional a May issue permitting scheme for public carry of handguns, much like the law challenged in this case. So after Bruen, the question before us is simple. That judge is saying that we don't need to send it back to the district court. We just need to say the law is unconstitutional and be done with this. Ninth Circuit is not quite so blunt. They're going to play the game as long as they can to delay justice. Hopefully not another 111 years. But they certainly have signaled that it's going back to Hawaii. And Hawaii, for their credit, has pretty much signaled that they're not going to enforce the May issue part of their law. They're going to be going to more of a shell issue. Maryland, New Jersey, Hawaii, Massachusetts all had the May issue language, and they've all had their attorney general come out and say, hey, in light of Bruen, we have to stop enforcing this May issue. We have to stop enforcing what is proper cause or good need or what their languages use. New York, on the other hand, is going to have to stop enforcing proper cause, but the New York legislature has been working hard to pass some laws to increase sensitive places. So, Ariana, get you to go back to the previous slide. The sensitive places are going to become the new method of attack, if you will, on concealed carry. So, it's sensitive places. Historically, if you look at those, they are where government decisions are being made. Legislative assemblies, that's the legislature making a decision about how we're going to govern our country. Polling places, that's the people making a decision about who we're going to put in charge. Courthouses, that's where the judiciary makes a decision about how we're going to enforce the law. This is not about places where we administer the law or where we carry out some other government function like a library or a school. The court, Supreme Court in Bruen, said that we can figure out new sensitive places using analogies to these oldest sensitive places. But one of the things that they put emphasis on was the word new. The place has to be new. So libraries existed in 1791 and 1867. Schools existed. Matter of fact, Times Square pretty much was in existence in the 1860s, though it was called Longacre, I believe. And Central Park was being developed as early as the 1850s. So New York is going to push the envelope and figure out what sensitive places means. I think that's going to be the next series of litigation we're going to see about where concealed carry would be, is many states start saying, hey, we're going to list sensitive places as, and then come out with a laundry list. In New York's case, I think they've declared all of Times Square businesses, unless the business posts that guns are welcomed, and some other, every other thing they can think to throw out there to make it inconvenient to carry. And that's a good point to put out. If you get to make a trip in a day and you're going to touch one prohibited place, it then becomes harder to carry, especially if you have to park on that prohibited place and you can't leave the gun in the vehicle. So the anti-gun forces in some of these states know that, and they try to make it as inconvenient as possible so that people just won't bother. I think we're going to see some fight over that. I see another question down here about fighting open carry bans. Actually, good question. I don't think, though, that we're going to see much on open carry. And the reason for that is that when we look back to what the court has done, where they put emphasis, they've looked at a lot of what I would call antebellum case law. There's a lot of antebellum case law about the concealed carry of guns. And most of those courts had said that, hey, the legislature can regulate how guns are carried as long as they allow guns to be carried. So absolute prohibition is not allowed, but you could require the guns to be carried openly, and you could regulate concealed. I think today, if we were looking at that from an honest perspective, we would more likely allow people to carry concealed and not carry open, and the idea that we don't want to, quote, scare people. That would really become an interesting debate if the court had found that you couldn't have a licensing regime. If we looked at this, the right, and said, hey, the right was never licensed, it was never asking government for permission to carry. If the court came back and said, we're going to strike down all licensing regimes, then we're probably going to see a stampede towards concealed versus open, would be my guess on that. Half the states already allow for permitless concealed carry. Most of the states allow for permitless open carry. We do have a few that don't. I think one of our commenters down there has listed, the precious few that don't allow open carry. And fortunately, my state is not on that list as of the last 11 months. So that is a number that's being pushed down. But because that historically we did have some allowance of how people carried, regulation of how people carried, I don't think we're going to see good arguments using Bruen on open versus concealed and whether you can prevent that unless they're preventing all carry of some item that is common for self-defense. For instance, if you allowed the carry of rifles but not the carry of pistols, I think that would be a question that would be well taken by the court, because rifles aren't typically what's used for self-defense. They're not the most convenient like pistols are. All right. So I got one more question here before I think I turn over to Ariana, and then I'm going to get some more questions back at the end. So I hope you all have some questions, but let's see what this last one here was. All right. So what will be done to enforce the U.S. Constitution? You're looking at it. Bruen, Duncan case is going up there right now. Bianche and Young, all those are ways which we're seeing the people, in this case, sometimes many organizations, push back with a judiciary and find out what is the realm of the Constitution. What does it cover? What doesn't allow? So that's one of the front lines. One of the other front lines is elections. And elections are actually two-pronged. One prong of the election is not getting bad law to begin with. We wouldn't be talking about the Sullivan Law here if New York had had a little more sense in 1911. The other part of the election is we wouldn't be talking about Bruen if our previous president hadn't appointed 3 originalist scholars to the Supreme Court that believe that the language means what the language says and that they can't read anything into it or read anything out of it. So that's an important part of this fight. And like I said, the other part of it is actually the challenge in the courts. That's where we give the opportunity for the courts to lay down where the limits are on government action. I will say that doesn't mean we need to bring every single case and every single challenge. You need to be smart and bring those that actually have a good chance at winning. And you got to be smart and pick the best jurisdictions for them if you're actually planning it out from a broad federal standpoint. Ariana, I think I'm over my time or at my time. I want to turn over to you for just a couple of minutes, and I'll come back and answer questions.
Sweet. Well, thank you, Robert, for all this helpful information. I know I learned a lot today, but you laid out all the start of the case and where it was led to today. And I was also aware of some of those new cases that you brought up for us to watch, which, as you can tell, the Bruen decision is already reshaping some concealed carry or gun laws already. Well, as we know, some of the reasons one may get their carry permit is to protect themselves with a weapon. But what happens after you protect yourself? You might have to go to trial to also defend yourself legally there, which may cost a lot of money. So before we get started with the Q&A portion of our webinar, I'm going to quickly discuss what Firearms Legal Protection has to offer for you. Firearms Legal Protection offers several different memberships to whoever is interested in signing up for legal protection. These plans are divided into individual plans and a family plan, which some benefits and pricing vary state by state. For the purposes of this webinar, we will look at our most common plans and benefits that are available in most states. The individual basic plan includes protection in your state of residence. It also includes an uncapped payment of attorney fees for defense of criminal and civil cases. Firearms Legal Protection memberships also extend to all legal weapons, including non-lethal weapons. With the individual basic plan, you also have Defense of Extreme Risk Protection Orders, also known as red flag laws. All plans have access to the 24/7 emergency attorney answered hotline, so no matter a time an incident may occur, you can count on our hotline and an attorney will pick up for immediate attorney-client privileges. You also have access to the MyFLP mobile app and one of our recently added benefits, expungement of criminal record on non-conviction incidents. Members of all plans also receive access to digital content and special discounts. The next step up is the individual premium plan. This plan has nationwide coverage and also includes all the benefits just mentioned and payment of bail bond premium, payment of expert witness and investigator fees if either are needed in your case. There's also coordination of counseling support, payment of lost wages if you are out of work during trial, and a list of other benefits. We also have the family premium plan to choose from for those who want the same protection also applied to their family. For just a little bit more, you get all the benefits that were just mentioned applied to your spouse and all minor children. If you want more information over these benefits, then check out our Instagram or Facebook page for uploaded explained benefit videos. Remember, if you, friends, or family are not already protected by firearms legal protection, please click the link below for a special discount we offer our webinar viewers. Now, let's get back to today's webinar. Alrighty, since I'm done discussing the amazing company I work for, we can now get started on answering some of those questions. These are going to be some of the pre-submitted questions that we do receive whenever people do sign up for our webinar. So just make sure you sign up in the future so we can get to your questions first. And of course, any comments that Robert didn't address during the webinar, we will get to those as well. But we'll start with Nathaniel's question. Per Bruen, is there legal grounds for cases against Florida's ban on open carry, assuming no such restriction was in place at the ratification of the 2nd and 14th Amendments?
So I touched on this a bit, and I think that Nathaniel here is trying to couch it as open carry prohibitions weren't allowed at the time of the adoption of the amendment, therefore they shouldn't be allowed now. I am more of the opinion I think the court would look at was the legislature allowed to regulate how guns were carried as long as they didn't prohibit all carry. That latter question is answered several times by prohibitions on concealed carry being upheld, not on open carry. If we allow that second question to be our kind of our guide stone that, hey, legislatures had the authority to regulate how guns were carried, they just didn't have the authority to prohibit the carry of guns, then I think the open carry prohibition is going to be upheld. If we're looking purely, could they prohibit open carry, then there's not really a good analogy for that, I think, that you can find in history. I just think that the court's going to look more to not what the exact language was, but what was the nature of the regulatory capacity that the legislatures had, and they had the regulatory capacity to regulate how guns were carried.
Awesome. All right. Clint's question. Do you think that this decision will lead to more reciprocity in CC permits? For example, my Arizona permit is valid in 37 states. However, it is not in California, Illinois, the two states that they travel to most.
So, quickly speaking, Bruen did not address reciprocity. And I don't know if there's going to be anything that's immediate on that. If we try to apply Bruen to reciprocity questions, then what we have to say is, hey, did the states at the time of the adoption of the Second Amendment treat citizens of other states differently? And I do use that wording very technically and correctly because at the adoption of the Constitution, we were independent states. And you were a citizen not of the United States, you were a citizen of which state you were resident in. So in Georgia, did they allow Georgians to carry and not Carolinians to carry? And we don't see that specifically. They just regulated the people as one. But if we also go to today and we see licenses, quite frankly, everywhere. You're all familiar with the driver's license. You're thinking that's ubiquitous. You can drive in any state there is. Your concealed carry license should be the exact same way. Well, the concealed carry license, let's just step back and hold that one back for a second. The driver's license is kind of an anomaly. There's lots of licenses you can have. I have one as a bar license. It's good in one state. You've got lots of licenses for businesses for practicing like a barber would have a license. You get business licenses, you get hunting licenses, and those are, again, they're good in a single state. That's the one state that, quotes, gives you that privilege. So in the middle between the license that's only good in that state issued and in the ubiquitous driver's license, we have the concealed carry license. Those are being allowed with reciprocity, sometimes as many as 37 states in Clinton's case. Other places, nobody has reciprocity with. So knowing that we've got this one in the middle, I think there's really, honestly, a whole lot more examples of very local licenses only good in one state versus the ubiquitous driver's license. But then again, those aren't constitutionally protected rights. And historically, there wasn't a differentiation between one state and the other state's citizens. That's going to be two pulls. I'm not sure which one the court would go down on.
All right. So we have bills.
See the criminal marriage license is being honored in every state. That is interesting. I don't know if we honor the license or if we honor the act of the marriage being brought together, which is an act that's legal and therefore falls under the idea that full faith and credit. So I don't know if I could get a license in South Carolina and then go get married in California under that license. But if I execute on it in South Carolina, they're going to recognize it.
Awesome. All right. First Line Firearms Academy has lots of questions tonight, but we got some answers for you. Okay. So another pre-submitted question. We have Bill's question. New York City is trying to turn the whole city into a sensitive area, namely Times Square. How long do you think it will take for the Supreme Court to shut that down, as well as other laws like that?
So how long it takes the Supreme Court to do something is a lot to do with how long it takes somebody to get it in front of the Supreme Court properly addressed. The Bruen Court was clear. I'm going to quote them because there's a good quote for this one. Put simply, there's no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. So I think the Supreme Court has tipped their hat on where they're going to go on this one, but getting it to them is going to be another matter. You have to remember, you're talking hundreds of thousands of dollars to get one of these cases, through the circuit court, through the district court before that, and then to tee it up and properly argue it. You're not only researching legal, you got to research all these historical examples and exhaust as much as you can to show those historical analogs or the lack thereof.
Right. I know New York has some great food, but their laws really just, it's the talk of most of our webinar. So, it's questionable and intense. But we have Miles' question here, again with New York, with the new New York law taking in effect and what clearly appears to be an attempt to limit carry anywhere, what can be done? More broadly, when can citizens legally carry across state lines?
So most of Miles' questions we've answered about citizens carrying legally across state lines. You have to look at what's allowed to be carried in this jurisdiction you're going. Reciprocity has not been addressed in Bruen, so there's nothing here that we're going to see immediately changed on. And then we're going to have to litigate out whether or not or what a sensitive place can mean. And that's just going to be one of those new developing areas of law that it may be another decade before the Supreme Court makes a decision that really pushes that.
Yeah, reciprocity is a huge question revolving around this. Chris's question. Will the new ruling allow CCW permit holders from other states to legally conceal carry in New York? Here's another one.
No. So while you're pulling the next one up, Aaron, I'm going to answer one of the questions out here. I see if I shoot someone in self-defense, am I going straight to jail in South Carolina regardless? I have seen it go both ways. I've seen clients pull the trigger in self-defense and I have to talk to them through jail. And I've seen others that never get arrested whatsoever. So it does depend upon how clear of a situation it is and how well the person can draw a bright line between self-defense and being the aggressor.
All right. So another question, Jason's question. New York governor just passed new gun restrictions limiting where we can carry our firearms. She's still trying to limit our constitutional rights. Can we beat her in court?
That remains to be seen. There's a lot of different places that have been called, quote, sensitive. You may win on some, lose on others. Much of it may be what is the makeup of the court when it finally gets to the Supreme Court. A couple more liberal justices on there, and I think that the entirety of the United States, from the Canadian border to the Mexican border, would be a sensitive place in their opinion. Your current makeup is probably going to be much more restricted.
Okay, we have two more questions that are pre-submitted. So if anyone else is wanting to have some questions, just make sure to leave it in the comments so we can get some answers to you before we end our webinar tonight. But we have JP's question. What recourse do Americans have when the state governments continue to infringe on two-way rights? For example, California's SB 918 bill that was almost passed, or New York's new gun-free zones.
I honestly wasn't aware that California and New York were free states. So, you could always move to a free state. Or perhaps more pertinently, if we don't want to give up the ship, work. You've got to educate those around you. They're the ones that make decisions on voting and who's elected. And you can't just, quote, go to work the month before the election. It's an educational campaign. And that's something you got to do year round, in and out, to show more people about why, guns are not a bad thing, why a certain ideology or certain belief can be a problem, or why perhaps, the free markets are better than another version. You get all these things that kind of tend to travel together. Now, my practice is mainly firearms, but I can tell you the general feel of most of my clients before they walk in the door, because I know what they think about guns. So many times if you focus only on that one part, you're not going to get a really dedicated person. But that's one of the biggest things you can do, is take that education, because in California, you avoided SB 918. Maybe with a little bit more education, you can continue to avoid it. Maybe one day, bring it back into the.
Yeah, that's a great answer. All right, so we have one more question. Nikki's question: when do you expect national reciprocity will occur? Another reciprocity question.
That's another reciprocity question. I would be slightly less accurate in making that prediction than I would be in calling the top of the stock market. So I'm not going to give a try on the when for that. I see over there, Angel has a question about when RPO qualifications in Jersey. I am not even familiar with the acronym RPO. That's not something that we have in South Carolina. So I will require some more input before I can answer that question at all. And then I think Scott asked about Nichols versus Newsom, an open carry case in California. I have not seen that one, so I can't provide you with any more details on that particular case. For all the guys asking about open carry, that's probably going to be the case that we see next, and that may be a very good one to study and look at. But off the top of my head, I can't tell you anything about it. Oh, I see a risk protection order, red flag law.
Maybe the RPO, is that what she was saying?
That Bob is guessing RPO is a risk protection order, or quote, red flag law. It's going to be interesting whether or not the red flag laws that are being promoted, and there's a lot of them, we haven't coalesced around some uniform system, if they are or if they meet due process requirements. So not even Second Amendment, just a general due process, 14th Amendment requirements. And if that due process is being given before you're taking property and arresting someone, I believe the courts actually might be a little more inclined to protect due process than they would the Second Amendment. And I don't know if a temporary action by the government when they think that somebody is criminally active, if that's going to be protected by the Second Amendment or not. So I'm not sure where the Second Amendment will fit in on that.
We also have a really good webinar from several months ago that goes into depth about red flag laws, so you guys can check that out as well. But Robert just had another comment. I don't know if that was one that you wanted to address. I'm reading it right now too.
So he says South is an open carry state. I'm guessing from a earlier comment is South Carolina. All right, so some states have a requirement that if you're stopped and asked for your identification, you have to produce your concealed weapons permit. Some states don't have that. I think North Carolina doesn't, South Carolina does. If you're stopped in our state and you're asked for your driver's license, your identification, you have to show them your concealed weapons permit if you are carrying pursuant to that permit. So that's a hat tip to all of y'all who might travel through South Carolina while carrying. So if in South Carolina, we also have open carry, but only with a permit. So what Robert's getting at here is if I'm openly carrying, can the officer just walk up to me and say, I want to see your permit? That is akin to me driving down the road and the officer seeing me driving and assuming that I am not driving with a license, and therefore he can pull me over just to see if I have a license. Quite frankly, that'd be very bad practice. The courts wouldn't hold that up. There is actually some case law that says that we presume legal activity. And when we see somebody pull out a wallet with money in it, we don't immediately ask, is it counterfeit? We presume without knowing more that people act in a legal manner. So I would say that an officer would not have that right. If you really want to push the point, the problem becomes it's expensive to push the point. And typically speaking, there's not going to be really damages from showing a license. But that is certainly one that you could make calls to superiors, make calls to the boss, especially if it is a sheriff's deputy, because sheriffs are elected. And many times the boss will get some education out in the department.
All right. Are there some other ones that are popping up that you want to discuss real quick before we end the webinar? Some of it's a little off topic, but
yeah, I'm seeing that. I'm looking for one that's a good one to end on here.
yeah.
So I guess since we're talking about concealed weapons permits, I'll end on Mark's question. I don't know whether or not New York could limit their permits to a resident. That's actually a really good question. Now I'm sitting here thinking about it. South Carolina, I pick on my state because I know it, has two types of permits, non-residential and residential. And non-residential is limited to people that have some type of property here or business here. Otherwise, we don't issue a regular permit to a non-resident. Some states, Utah, I think, will issue it to anybody that wants to send them $50. So the question becomes one of, could a out-of-state citizen ask for a New York permit? And could New York deny a commoner from another state the ability to carry? And that's actually a very good question, because that is denying a class of person who is just the average Joe wanting to protect himself. I suspect we're going to have to see more litigation on that one, just because it wasn't in the Bruen decision. There was nothing in there talking about, hey, can we fence off between those we give permits to and those we don't give permits to based off of geographical boundaries. They were fencing off based off of, quote, proper need or good cause, looking at some of the other may issue states, but not geographically. By default, they've been getting away with the broader fencing. So now it's going to be a good question of, can states be forced to issue to anybody, not just to their own residents? If we look at driver's licenses, again, I like to pick on those. You can only get a driver's license in the state that you reside. You're not supposed to have two. And most states will require you to surrender all your active driver's licenses before you get one from them. But then again, they all honor driver's licenses, so it's not really an issue. So, Mark, it's a good question. It's one I don't have a solid answer to, but that may be the reciprocity lawsuit. That might be it right there.
All right. Do you have any other last comments that you want before I just send us out?
Ariana, I'm going to turn it over to you, but I thank all y'all for attending. And if I can ever help anyone with an issue, by all means, reach out.
Awesome. Well, I guess that does sum it up for today's webinar. If you do have any additional questions, please just email marketing@firearmslegal.com. Thank you again, Robert, for sharing your extensive knowledge over this Bruen decision. But remember to click the links in the captions below so you can get protected at a discounted rate, and to also let us know what you would like to see in any of our future webinars. Also, if you enjoy content like this, then make sure you like our Facebook page and hit the subscribe button below and the little bell on YouTube to receive a notification whenever we go live for webinars like this in the future. And make sure to enter our giveaway. The link is in the description below as well. But I hope you all have a great rest of your night. And remember, protect yourself will protect you. See ya.